Call the next case on the 9 a.m. docket, State of Kansas versus Kyle Vincent Hardwick. Case number 126317. Counsel, you may approach when you're ready.
May it please the court, Sean Randall of the Appellate Defender Office on behalf of Kyle Hardwick. Your Honor, may I request 3 minutes for rebuttal?
You may. Thank you.
Thank you, Your Honor. If Your Honors don't mind, I'd like to begin my argument this morning by addressing issue 2 in my brief concerning Mr. Hardwick's right to remain silent and the state's attempt to elicit testimony concerning his exercise of that right. And I'd like to actually begin that argument by quoting to you the police caution that's read to suspects when they're arrested in England. And it's very similar to our Miranda warning, but it says, "You do not have to say anything. But it may harm your defense if you do not mention when questioned something which you later rely on in court. Anything you do say may be given in evidence." The reason why I bring that up is because it's that second sentence that doesn't appear in our Miranda warnings that does appear in theirs. That is the exact importance that this court needs to be relying on or focusing on in this case. And that's whether or not, if you exercise your right to remain silent, if you don't tell the police what your defense is immediately upon being arrested, does the state get to come back later on in trial and say, don't believe it because he didn't tell you when he was arrested, because he didn't tell you that when he had the first opportunity to do so. And I think this court has held routinely, and for at least, going back to, I think 1977 was the first case that I found, that, it says that a defendant is under no duty to volunteer an exculpatory story. He does not have to tell the police, this is what I'm going to rely on when I go to trial. This is what I'm going to tell you. This is my defense. This is why I was justified. Those are things that he did and eventually obviously did present to a jury, and that was his defense, but he doesn't have to tell the police what that defense is immediately when he's taken into custody. I know that there was a significant amount of discussion in both the briefs and at the district court, down below, as to whether we've got some statements that were made after he was arrested, but before Miranda warnings were given, and then some statements that were made or some comments that were made about his silence, after his Miranda warnings. And I don't really know if that's a significant difference that this court needs to be focusing on. The only difference that it implies is that the United States Supreme Court case of Doyle most certainly applies in the situation where you've been arrested and you've been informed of your Miranda rights. I guess there's a question as to whether or not Doyle applies when you've been arrested, but you haven't made your Miranda rights. But the factual underpinnings are the same. If you have a legal right to remain silent, if you have a legal right to not incriminate yourself, then that legal right exists irrespective of when and whether the state informs you of that right.
I'm getting a little confused here. So I thought that the question presented had to do with not going all the way back to what you're saying, but whether defendant opened the door to the testimony. Because Doyle just basically says, a comment on, in this particular instance, because, there was no contemporaneous objection to the pre-Miranda silence, but under the post-Miranda silence, the general rule under Doyle is that it's generally inadmissible for impeachment or substantive purposes, but the whole issue was whether defendant opened the door. Am I wrong about that? I mean, you're talking about...
Well, I think when we are focusing specifically on the post-Miranda, or I guess the post-arrest, post-Miranda statements, because you had indicated the pre-ones, there wasn't a contemporaneous objection during those. But I think when we're focusing on that, yes, we do have to focus on the, whether or not Mr. Hardwick opened the door.
Right.
And that was certainly the discussion down at district court and why the district court
and that's the basis for your appeal, right?
Yes. And I think what's important is the case that was relied on by the state when they were making that argument in district court is the same one that I would now rely on to you, which is State versus Tully. What the state failed to mention in State versus Tully is what this court actually, ended up relying on, which was, yes, he said some things. Yes, he might have cracked the door, but that doesn't throw the door wide open. It says if the defendant later on at trial gives this idea of being cooperative, then the state gets the ability to come back and say, no, you weren't cooperative. That's basically what the decision was. They defined cooperative as blatantly inconsistent with your trial testimony. That's how cooperative was being defined. His statement was, I would have talked if you would have given me attorney. His defense at trial was, I shot these people, but I was allowed to do so. I was justified. I was exercising self-defense. This idea of, I would have talked to you and I would have made statements if I had an attorney, and I'm justified because I have self-defense, are not blatantly inconsistent. One does not, and I would look at the language of this court.
Isn't it inconsistent with the fact that once he got an attorney, he didn't talk? Because his, it was a qualified thing. Well, I'll talk if I get an attorney. And then he got an attorney and he didn't talk.
Well, after perhaps getting legal advice, from I think any criminal defense attorney who would do so, and probably told him not to. But I don't think that's not.
I thought that was the basis for the district court's decision.
The district court's decision, I think, was that he found that Mr. Hardwick had opened the door,
right,
and had and relied on this statement of, well, he's giving this impression of being cooperative, Your Honor, and I would just argue that this definition of cooperative, of blatantly inconsistent, is different than what we've got here by him just making that statement, because his defense wasn't based on his exercising of his right. His defense was, I was justified in shooting these people.
Well, isn't that the whole point? Is that he never mentioned that he was, I mean,
and
his whole thing was, I'm Mr. Cooperative.
Well, but see, I don't think his whole thing was, I'm Mr. Cooperative. I think his whole thing was, I would have made statements to you if you gave me an attorney. That's the extent. Until it's the only time that the word cooperative even gets used is on cross-examination after he's testified, when it's brought out by the state. He never makes any claim that he was cooperative when he got up on direct examination. He never used that word. The only thing was, I would have talked if they gave me an attorney. But this idea of whether he got an attorney later on and then chose not to make any statements, and that's different than what he said that he would have done. He doesn't, that's kind of the whole point, is that he has this right to remain silent. He doesn't have to talk to you or to the police. That's the right of your right to remain silent that exists irrespective of when the state tells you about that right.
But the blatant inconsistency is, okay, I didn't talk because I have a right to remain silent. But then he gets up there on the stand and says, I'm Mr. Cooperative. I mean, how can it be more blatantly inconsistent than that?
Because I think it's not whether or not I would have talked is inconsistent with the fact that I didn't talk. Is I would talk with an attorney inconsistent with his defense. And I think the defense here is not, I would have talked. The defense is, I'm justified in using self-defense when I shot these people. I don't believe the statement of I will talk is inconsistent with that.
Right, but the whole point is saying, if that's what it was, self-defense, why didn't you mention it when you got an attorney?
Because he doesn't have to.
Okay, we're talking beyond each other.
Well, I don't intend to do that, Your Honor. I'm not.
No, I wasn't saying that.
Okay.
So following up on that, how would you articulate your position that what the state did here was using the post Miranda silence to infer guilt?
I would say that by using his post Miranda silence, they are inherently attacking his credibility. That's the point.
That's what it's permitted for, to impeach. In other words, I guess I want you to talk about, is there really a difference between impeachment and an inference of guilt? That Tully seems to think those two are two different things. And your argument, it strikes me, your argument is those aren't two different things. If you're impeaching somebody's credibility, you're inferring guilt.
Well, it's certainly one way to infer guilt. I mean, I guess I would say that.
Was there any inference of guilt beyond impeachment?
I don't know if there was any other inference. I mean, the inference certainly was, don't believe his testimony.
Well,
I
don't believe his testimony with respect to why he did or did not talk.
Well, and also don't believe his testimony about, I mean, what he says occurred that resulted in, that resulted in.
Yeah, I guess that's what I'm driving at is can we really draw that line so brightly between impeachment and inference of guilt?
I think what this court can say is that impeachment is one way to infer guilt, but there are other ways to infer guilt. I wouldn't say that the two terms are synonymous, I guess is what I'm trying to say.
So I guess what I'm hearing from you is that you are conceding that there was no inference of guilt beyond the impeachment purposes.
As long as the impeachment is understood that it was various different things. It was not only I would talk if I gave an attorney, it was also this is what I was doing when I came here and why I came here, about whether or not I knew there was silver there. I mean, it was his answers and his version of the events, which were widely different from the state's. I mean, it was an impeachment generally regarding his entire version of the event.
You're making if you lie about one thing, you probably lied about other things argument.
I think that's what in fact, I don't think that's what the state was doing. If they had done that, perhaps we wouldn't find ourselves in this situation, but it was repeated with every single law enforcement officer. He didn't tell you about this. He didn't say this. He didn't do this. When we're talking about the officers that arrested him in Mays, Kansas, when we're talking about the officers that picked him up and drove him back to Reno County, when we're talking about the officer that sat with him for 40 minutes before the detective came down, and then the detective, I mean,
I'm just trying to understand, because Tully says that you have to stray beyond impeachment to an inference of guilt. So how do those questions infer guilt? How do those questions about you didn't tell, you didn't talk, you didn't talk, you didn't talk, how does that infer guilt?
Because I think there's a lot of people that find themselves, when getting questioned by police, if I don't talk, I'm going to look guilty. I think and why wouldn't you talk if you had nothing to hide? I mean, I think this idea is certainly if you would have talked, you wouldn't have looked as guilty.
Wasn't it more than that though? Wasn't it that or maybe I'm reading the record wrong, but that if you talk, what the talking about was entirely related to helping them find evidence that would have supported his self-defense claim. Is that an accurate or reflection of the record?
If I understand your question correctly, I mean, there was testimony about, yes, if you would have come to us immediately, this claim about rape, maybe we could have found DNA evidence or something along those lines, or we could have found these weapons that you were looking for. If you hadn't burned them, there would have been I mean, there was testimony about, I guess, those things.
It seemed to me that the impeachment seems to be pretty closely tied into the self-defense theory.
I would certainly agree. As I was trying to respond to Justice Stiegel, I think it's not just this, you were lying to us about you would have talked to us about the attorney. It's you're lying to us about everything from the moment that you got up on the stand and told us what happened to the moment that you got off the stand. All of that was a lie. And I think it goes to everything about that, Your Honor.
But wouldn't that happen in every case? I mean, then it basically swallows the rule that you can use it for impeachment. Because isn't that the whole thing of, impeachment? Yeah, you lied here. And then there is going to be, I mean, you lie once and maybe everything, that you say later is not truthful. How can you separate that? That's always going to happen.
Because I think they're two different things. And if I don't answer your question, let me know and I'll keep trying. But I think there's a difference between a prior inconsistent statement, which can be used as evidence of lying, and just not saying anything at all. I think those are two different things.
Wouldn't we have to overrule Tully? Because Tully says you can use it for impeachment. And so if you can use it for impeachment, it seems like in every case, if you impeach somebody's testimony and to create an inference that the person's lying, then people are always going to question whether the next thing that comes out of your mouth is a lie. So to accept your argument, wouldn't we have to overrule Tully?
I don't think you have to overrule Tully. And
Give me an example when that wouldn't be the case.
when someone is, again, in situations where someone said something previously that is now different than what they testify at trial, then certainly, yes, I would say at that point, you've given contradictory information and statements versus giving a statement at trial and having giving no statement or exercising your right to remain silent previously.
What he said at trial was, I'm Mr. Cooperative.
Well, the state used the word cooperative. He did say I would have talked if I had an attorney.
And he said it more than once.
Yes, or I think his attorney elicited that confirmation from him multiple times. But again, when we're talking about cooperative, when we're talking, and Tully uses the word of a defendant just by making a statement, okay, and cracking the door, that Tully specifically says that the state is not given free range to then throw the door wide open and go forward. I think his testimony and his statement that he made at trial was, I would have talked if I got an attorney. I don't think that's so blatantly inconsistent and so evincing this cooperative spirit to dispel his entire defense or be contradictory to his defense, to be blatantly inconsistent with it. Obviously, I'm over my time and I haven't had an opportunity to discuss involuntary manslaughter or voluntary manslaughter. Or if there's any questions about that, or otherwise I'll sit down and wait for rebuttal.
Any questions, colleagues? Thank you, Mr. Randall.
Thank you.
Mr. Stanton.
May it please the court, counsel, Thomas R. Stanton, Reno County District Attorney, appearing for the state. Your honors, I'll start just with the initial statements made by appellate counsel in that asking you to look at English law. English law is not based on our constitution. It's not based on our statutes. It's not based on our case law. So I would ask you just to disregard that argument. First of all, I'm not even sure this was preserved for appeal. There were no objections to any of this information coming in. And we have to be clear. I've heard a lot of comments about post-Miranda statements here. There was only one post-Miranda statement that was even discussed. And it was brought up because of defense counsel, because defense counsel asked his client, why did you ask detective, the detective about where you were going to, if you're going to jail or you're going to prison? And your response was, well, good, I'm going to jail. Maybe I won't get raped. And that was supposed to elicit some sort of investigation by defense counsel. That was the only statement made post-Miranda. Every other statement made, or any inference of not making any statements, were between the time of his arrest and prior to his arrest and the time he was Mirandized. And if you look at the record, I was very careful, because I'm aware of Doyle. I was very careful not to introduce any of those statements. He didn't make any claims of being raped to the two people who saw him first, Kathy and Dawn. He made no claims of rape or anything to the people who allegedly picked him up and drove him from after he hid the truck in the maze. He made his whole statement of going to maze was this: I thought that they were well connected in Reno County, and so I'm going to go to a different jurisdiction where the officers can be trusted, and I'm going to contact them and tell them what happened. He gets there August 28th. On August 30th, he's making purchases in a store. Doesn't tell anybody that he was raped. Doesn't say he had just shot two people. Doesn't tell any citizens. And when he has his contact with law enforcement, he says nothing. So there's one instance where he says, I was going to be cooperative. Then he also says during his testimony, well, I was going to show the officers where all the evidence was. He was given those opportunities. He had 3 different attorneys. Now, it may be that the attorney said you shouldn't talk, but but they brought it up. It wasn't something the state brought up. That was the strategy on defense part to fool the jury. My brief includes a statement by defense counsel specifically stating, we want the jury to hear that he was cooperative, that he would have talked if he'd gotten an attorney. That was a defense strategy. He wanted to paint himself as the victim at that point in time, and that he would have been cooperative. But he wasn't cooperative. There's no way a detective looking at that or hearing the statement, I'm going to jail, at least I won't get raped, would say, oh, was there a rape allegation here? He never made a rape allegation. He destroyed every single piece of evidence that would have supported his supposed self-defense. He destroyed the guns that he said that the victims had. He destroyed the murder weapon. He destroyed all the evidence that showed that Phil was strapped in, it was zip tied in a chair when he was burned. He was murdered and then his body burned. His description of where people were shot was absolutely contrary to all of the forensic evidence. There was no blood evidence found outside the fire pit. We know he wasn't killed where Phil wasn't killed where he said he was. Phil was standing in front of a white trailer, according to the defendant, when he was shot, and there's no blood spatter and no pellet damage, and there's no blood where he supposedly laid for 24 hours.
Counsel, your whole argument is compelling with respect to did the evidence match the defendant's story, but it also kind of plays right into my and some of the other justices' questions about the difference between impeachment and inference of guilt. And your presentation is, look, this guy lied about everything. And so I want you to address the Tully question. And I think we're probably all in agreement about what Tully says. It says you can impeach the claim that I was cooperative by referencing silence, but you can't stray beyond impeachment to an inference of guilt. And I just want you to talk a little bit about, does that really make sense? Is that a manageable standard which we can apply?
It does, Judge, because I have to admit, I'm talking about whether it was even if this issue is even preserved. First of all, there was no discussion about that. I don't think it's preserved. I don't see how this court can rule on it. There was a specific question asked by the judge, and whether there were going to be any objections. He said no. So I also started getting into my overwhelming evidence argument. The importance of this impeachment was that he had the opportunity to say all these things pre-Miranda. All of these statements were pre-Miranda, and I think we're getting into a little bit of a quandary here, because I thought we were going to be here today to talk about whether or not the pre-Miranda statements were admissible under the law, and that's kind of what I argued. But these were all pre-Miranda statements, and they were not objected to. The only statement post-Miranda that can even be considered by the court is the one I discussed, and that was direct. It was a direct result of defense attorney asking the defendant questions. That was the only post-Miranda statement that was even in the record.
Well, wasn't there evidence that introduced by the state that he did not talk post-Miranda?
Well, as far as whether or not, so you're now asking about the question of whether or not it was proper for the court to allow the state to ask whether he was Mirandized.
No, and I might be misremembering or just misunderstood the record, but I understood the argument to be that the state introduced evidence that he was not cooperative post-Miranda.
The only statement, if you look at all of the statements There were two, I guess there were two. The one was when the defense attorney asked the defendant, did you inquire as to where you were going to be incarcerated? And he said, yes. I asked him if I was going to jail or to prison. And and his response was,
Right, but
well, I told him that, and I said, at least I won't be raped. And that inquiry went from there because he's now inferring that the officer didn't do his job and somehow should have known that.
right, but we're not talking about statements. We're talking about the lack of statements, right? We're talking about silence.
we didn't talk about lack of statements post Miranda. The judge made a ruling that we could not talk about post Miranda silence.
Okay, so your position is there was no evidence about post Miranda silence introduced. That's your position.
The only place that would apply, Judge, is when he said I would have spoken to them about stuff had I had an attorney. Because those statements would have come after Miranda.
Okay.
But all the other statements, all the other questions were observations. Did you tell Kathy and Don that you'd been raped? Did you tell, this was post-arrest, it was pre-arrest. Did you tell the people who picked you up that you'd been raped? Pre-arrest. Did you tell the officers?
So just to summarize, your position is, as I understand it, that every time the state introduced evidence of silence, it was in reference to silence pre-Miranda. And then the follow-up would be that all of those pre-Miranda instances were not preserved because there was no contemporaneous objection.
Correct.
Okay.
Correct. Except for those two I discussed with you, which were directly related to his testimony.
Right, but that's not silence. That's about something he said, right?
That's true.
Okay.
But if you look at my brief, I go through it and so talk about all the times that there was an inquiry as to what was going on and if they had made any observations of injury, and if he'd said anything about injury. It was all pre-Miranda. I thought that's
maybe I'm not reading the record right. I thought wasn't there a comment, or I think maybe you asked the judge and there was a bench hearing. Look, he's saying that it was like when he was testifying and he was saying he was cooperative.
I did say that. Okay, so let me.
Right, and then you said that he's just opened the door to impeachment.
Okay.
And so I want to introduce evidence that he didn't tell us any of this. He wasn't cooperative after the Miranda was given.
I was concerned, actually, Your Honor, I was concerned about the fact that that they kept bringing up this issue in front of the jury.
Right.
And so the first time I went to the bench outside the presence of the jury, we talked about the fact that if he kept doing this, it would open up some of those issues.
Right.
And that was a kind of a warning. And the judge came back on the record and said, I'm going to warn you, if you keep doing this,
Okay.
then these statements
That's
are going to.
how I remember it. And then
he continued to do it.
Right.
And then I said, at this point, he has opened the door to what I was talking about was not the statements themselves. If you look at it, it was whether I could bring in an officer to say specifically that he invoked his Miranda. And in fact, the defense during that argument was saying, well, we're saying he didn't invoke Miranda, that he didn't invoke his right to silence.
So I'm hearing contradictory things. I understood you to say in response to my questions that the state had never introduced evidence of post Miranda silence, but I understood you just now to say he did do that.
I wasn't thinking of just.
No, that's fine. I appreciate the confusing nature. I just want to get clarity.
So yes, the state introduced evidence that he had been read his rights and had chosen to invoke his
Okay,
rights.
and then with
That
respect
we
to
did.
preservation, do you agree that that issue is preserved for our review? Because it was objected to by the defense.
I'm, Judge, I just recall the judge specifically asking him if he was objecting to any of this, and he said no. If there's an objection.
But when you had the bench conference about opening the door,
If-
defendant didn't agree with that, did he?
The record speaks for itself on that. I'm assuming that that's correct, Judge, because you wouldn't be asking me the question if that's not what happened. So I would say that particular issue, those, whatever statements that is, that issue of whether or not I could do that is preserved.
Okay.
And then I guess we have to get into what, if it's preserved, would it have made any difference at all?
Well, that goes to my very first question, which was this Tully rule about the difference between impeachment and inference of guilt. Your position, I
think it was clearly impeachment.
Yeah.
And if you look at this record, and I think I've already argued that his statements were completely contradictory from his direct examination to my cross-examination. I don't know how many times he changed his story. I don't know how many times he said things that were absolutely untrue. It was clearly, and even at one point he says, kind of sort of making this up as we go along. We're building this as we go along, which I think I responded, you mean you're just making this up as you go? And I can't, there's no way to preserve the look on his face when I asked that question. But clearly, this case, the convictions in this case were strong, and I don't believe that any constitutional or reversible error occurred. I would ask the court to affirm the convictions. I have 21 seconds if you have any questions, or if you want to ask me about the lesser included issue.
Any questions, colleagues?
Thank you for the opportunity to argue before you.
Thank you.
This morning.
You reserved 3 minutes.
I did. And thank you very much, Your Honor. May it please the court. I will only just address a few things. It's page 525 of volume 10, where the court specifically asked Mr. Loftus, are you objecting to the admission of post Miranda silence? And his response is yes, Your Honor, because it was counsel's questions that elicited a response. So I think we do have a very clear objection and preservation to that. The only other thing that I'd like to highlight, Your Honors, is that we're talking a lot about statements that were made, and we're focusing not on the statements that were made, but the statements that weren't made. There's a difference between the things that he said post Miranda and the things that he said pre Miranda and the things that he didn't say. And it's the things that he didn't say that he's allowed not to say and that the state doesn't get to use against him. I've been thinking about
sorry, just real quickly, clean up. Do you agree there was no objection to the evidence about his silence pre Miranda?
And generally, I would respond, yes, Your Honor, that I would concede that. Obviously, there's exceptions to the preservation requirement, and I'm asking those.
Those exceptions don't apply to 6404 issues, though. Those are evidentiary issues that we're dealing with. So how do you bootleg some other exceptions into this deal?
Because the evidentiary issue deals with fundamental constitutional rights under the Fifth Amendment, and so when you can't raise new constitutional issues generally for the first time on appeal, I would say this is generally dealing with a fundamental constitutional right to remain silent and not incriminate yourself. So that would be my response to that. I wanted to address what I think kind of you've been highlighting, Justice Steele, is there a difference between impeachment and inference of guilt? And I think what I was trying to say initially was that there is a difference, but I think it's kind of like the square and rectangle situation. I think impeachment is always going to be inferring guilt, but there are other ways to infer guilt other than through impeachment. But I guess we don't really have to answer that question here today, because Maybe this court does have to determine whether there's a difference. I know in this case, they were inferring his guilt through impeaching and saying he was not being
So
credible.
it sounds like you're agreeing or that you're answering one of my earlier questions. If impeachment and inference of guilt form a Venn diagram, or where impeachment is wholly enclosed within the bigger circle of inference of guilt, it sounded like you just said that what was happening here was an inference of guilt through impeachment only. There was no inference of guilt that fell outside that smaller circle of impeachment.
True.
Okay.
As long as we understand that the small circle of impeachment, again, is not just
I
about.
understand your argument
Oh.
is it's wholly encompassed
Thank you.
in an inference of guilt.
Yes.
Yeah.
Yes. Thank you, Your Honor. Any other questions, Your Honors? Okay.
Thank you.
Thank you very much.
Thank you all for your argument this morning. This matter will be taken now under advisement by myself and my colleagues.